Hello, everyone. Welcome to the IROE Talk. And today we have a very special guest from far away. Welcome to Indonesia, Professor Manfredi. So we have a rare and important opportunity today with one of the world's leading expert in politics of law, and especially you are looking at the role of courts in constitutional democracies. And I think that is a very important issue right now in Indonesia. So, Professor Manfredi is a professor of political science from McGill University in Canada. But he is also serving as acting principal and provost and vice principal academic at McGill University. But now you are coming here as a political scientist.
Absolutely. Thanks for the welcome. And my administrative title is Provost and Executive Vice President Academic, but I'm not here in that capacity, of course. I'm here in my capacity as a political scientist. So I'm not here representing the views of McGill University. I'm just speaking about my own scholarship and expertise.
Yeah, that's fortunate for me because I will have to ask you some questions that might be better to be answered by political scientists, not by a provost. So, Professor, you are coming to Indonesia at a very opportune time. So this week, on Monday, 22nd of April, the Constitutional Court just issued its verdict on the election issue, which was proposed by the number 1 and number 3 candidates, Anies Baswedan, Muhaimin Iskandar, and Ganjar Pranowo and Mahfud MD, which claimed that there are so many systemic irregularities in the 2024 elections, and thus there should be some legal consequences for that, including the cancellation of the result. But the court decided to reject the request and argue that the election is conducted relatively well and does not breach any legal election regulations, and thus the result is legitimate. How do you see, as a political scientist, looking at different countries, how do you see this? Because in Indonesia, people seeing this as some experts, some observers seeing this as another symptom of a backsliding of democracy, and the court is doing a role in that. Do you see that way?
Well, it's a very interesting question, and it's very fortunate that I arrived the week that I did. You'd almost think that I knew what was going to happen when I gave you the title for today's podcast. Of course, I haven't read the decision. I've only read reports about the decision. And I think as I look at it, there are 3 things that stand out about the decision. The first, of course, is that it is a decision that really tells us that the line between law and politics is very narrow. Many people ask me, as a political scientist, why am I studying courts and judges and the law? Because law and politics are two separate areas. And I say, no, law and politics are very closely intertwined. So I think anytime you have a judicial decision that is about an election outcome or about how elections are going to be run, it really illustrates the interconnection between law and politics. So that's one thing that I observed. The second aspect of the case that's very interesting to me as a political scientist is that, of course, it was a split decision. It was a 5-3 decision, which means what's interesting about that is you have 8 judges who we assume have basically the same training, are of probably equal intelligence, they're applying the same law to the same facts,
With different
and yet they come
interpretation.
with different conclusions. So as a political scientist, one of the things we want to understand is, why do judges decide cases the way they do? It's not always just the law. There's something else underneath it. And so as political scientists studying courts, we try to dig up or dig under the decisions to try to understand where they come from. So for me, this would be a very important and interesting case for people to study, because it is a split decision. And the third thing I think it illustrates, and this may go against a little bit of the backsliding perception, is that if there is one area where courts ought to be involved, regardless of the outcome, it's in refereeing the rules around the political system. Because you can't always rely on the political actors to do that, because they're self-interested.
Yeah.
You know, they have an incentive or an interest in having rules that give them advantages. So I think it's always important, if there's any area where courts should be more active than others, it's in, I would say, to use a term from, or paraphrase a term from the American legal scholar John Hart Ely, it's about policing the process of representation. And so I think this is
Policing the process of representation.
Policing the process of representation. Not necessarily the outcomes of representation, but making sure that the process is fair, is done according to the rules. And in this instance, of course, a majority of the court decided that was the case. And from my reading over the last couple of days, and I think this is another good example of democracy, is that all of the parties are, if not happy with the outcome, are willing to live with the outcome, and you're going to have a peaceful transition of power, which is always a mark of a strong democracy.
Rather than a backsliding of democracy, you see the process and at least the result and the response of the other candidates to the result is an indicator that
in the limited time that I've been here and been able to read about the result, it seems to me that, and again, I take no position on who the better candidate was or what the result should have been, but it seems to me that the acceptance of all parties with the outcome, I think, is a good sign for democracy.
Yeah. Again, returning to your three observations, your first observation is the importance of the entanglement between politics and law, and we cannot see law as something that is independent from politics. And one of the main concerns, I think, in these several years is that politics increasingly encroach into the judicative branch of the government, of the trias politica in Indonesia. I believe that you have looked at different cases at global level. Do you see any pattern at global level on how these different courts are playing their role in politics or being influenced in politics? And when should we be prepared to ensure that the division of power, that the checks and balances are continue to work?
So that's, again, a very interesting question. So I'm going to maybe say something that sounds radical. When we talk about final courts of appeal, like the Constitutional Court of Indonesia or the Supreme Court of Canada, the court that with which I'm most familiar, I'm going to say something radical. These are not legal institutions. These are political institutions.
Oh, that's interesting.
From my point of view. And what that means is that they make policy not as an accidental byproduct of deciding cases, but they make policy because a majority of the judges believe that one outcome is better for society than the other outcome. Now, why do I say that? I say that because cases reach final courts of appeal precisely because the law is ambiguous. If the law were clear, then you wouldn't need to go all the way up to the highest court. in most cases. So the law is ambiguous, which means some other factor comes into play in making a decision. So for me, to say that a final court of appeal is political is just a fact. It's not it's not a criticism. That doesn't mean they can't be too political, but they are, from my point of view,
they're by default political.
By default, they are political institutions, and that means that appointments to those bodies are always going to be by default political in nature, and no matter what the process for appointing the judges is. So, from my point of view, that's so. And it's important, if you start by recognizing that, then I think you're actually better off in being able to understand what these kinds of courts do, and and also being able to criticize them better, because if you think of them as just legal institutions, they're almost above criticism. But if you think of them as political institutions, then you can disagree with their policy preferences. So that's something that I think is a really important. For me, it's an important premise with which I start my study of the courts.
But isn't that contradictory with the role of policing the process? Because if you are policing the process, you have to be impartial, right? Because if you are part of the political actors,
right,
then you cannot really becoming impartial in ensuring the process, right?
That's a very good question, but I think you have to understand there's a difference between being political and being partial. When I say that they're political, I'm not saying that they're partisans for one party or another. I'm saying that every decision they make is a political decision, which is not. I'm not impugning their independence or their impartiality from electoral politics. So I think one has to be careful about making that clear. So I think that's important. And I think, but you raise a very good point, and that's the point of, if you think about what do constitutions do? Constitutions put limits on what government can do. They put limits on political power. That's what a constitution is for. So the question you raise is, if courts are the arbiters of what the Constitution means, and they're political, how do you limit the political power of courts? That's the question you've posed. And that's a very important question, and one that political scientists who study courts have struggled with for a very long time, probably since the 1930s.
What is your answer among
those my answer is that the answer has to lie in the structure of the Constitution itself. The Constitution has to have those limits. So I'll just give you two examples from Canada, which is so in Canada, our Charter of Rights and Freedoms, which is like the U.S. Bill of Rights, starts out with what's called a reasonable limits clause. It says that the rights contained, the rights that are within the rights that are guaranteed by the Charter are subject to such reasonable limitations, such limitations as are reasonable in a free and democratic society. So what does that mean? It means that even if the legislature violates a right, they can justify that violation as a reasonable limit on the right. And so that is a way of giving an important role to the legislatures in terms of determining the balance between rights and legislation. The other structural element that we have in Canada, which is much more controversial, is something called the notwithstanding clause. And that says that legislatures may declare for up to a 5-year period that a law shall operate notwithstanding the violation of or the alleged violation of a charter of right within our charter, which means again the last word is given to some degree to the political actors. To the political actors. So the final court has these two limitations on its exercise of political power. So the idea is to try to create a balance between the political power of the legislature and the executive and the political power of the courts. And that's a very tricky balance. I think it's a balance that courts themselves are interested in preserving, because their political power depends upon their legitimacy. And if they exercise their political power too strongly, they risk losing their legitimacy.
That's the problem which comes from powerful court. What if the case is reversed? I mean, a political actor outside the court is becoming very powerful, and then its dominance has reached the court and making the court being subordinated functionally, or substantially by this actor.
Very, very good question. Let me be very clear. Judicial review exercised by courts is an essential element of constitutional democracy. Courts have an essential role to play in determining what the constitutional limits on other political power might be. So it's a critical element of that. So the question then becomes, what if the courts become too weak in exercising that power? That's what you're asking. And that's a real danger, because as the founders of the US Constitution said in the Federalist Papers, the courts have neither the power of the sword nor the purse. So they don't control an army, and they don't control the money. So they are in some sense already relatively weaker. So my argument would be actually that if you get to a point where courts are so weak that they're unable to perform this essential function, then you've probably got a real, almost a cancer at the heart of your democracy. And there's not much that you can do about it, other than, and I'm not saying, I think there are very few places where that exists, but in other words, there is a point where that almost is a breakdown in constitutional democracy, and that's a very serious problem for a democratic society.
I think you made a very strong and powerful point, that the weakening of the court, especially the final court, the constitutional court, is something that could mark there is a cancer in the constitutional democracy. And if we are looking at the current trends, not only in countries like Indonesia, we witness that there are some efforts to somehow subjugate this constitutional court. Right? I mean, in Israel, Netanyahu was in the battle to weaken the constitutional court. I think in some other countries as well, there are fights on how to defend the court or to weaken the court. And I also just read an article on Malawi, which is very interesting. I mean, Malawi has a lot of requirements to be a failed democracy, but it is still standing strong as a democracy, because the court is strong enough to resist such pressures to the backsliding of democracy. So, I mean, you are rather pessimistic by saying that if that is happening, I
mean, if it goes, I can't say you're.
Is there anything?
Let me put it this way. I think the solution is a political solution.
Okay, so it's not in the court.
It's not in the court. It's a political solution in which the people have to stand up for their democracy. But I do want to say that you can also go in the other direction. If you have too much of a shift of balance of power from legislatures and executives to the court, if courts get too powerful, you can end up with something that the American legal scholar Mark Tushnet calls democratic debilitation. That is, if you rely too much on courts to solve your most complex social problems, it creates a kind of a weakening of democracy. And so you can think of all sorts of different controversial issues that a society might face. And if they say, well, let's not decide it politically, let's let the courts decide it, it's kind of an atrophying of democracy. So I think that's just as dangerous as the legislature and executive getting too powerful.
Yeah. So too powerful is bad, too weak is also bad.
Exactly.
So we need to.
But that means the citizens have to be constantly engaged. I think democracies become dysfunctional when their citizens become disengaged.
That's a very important point.
And I think that's happening a lot, unfortunately, in a lot of different countries for different reasons.
So I think this is important. Too strong, a court that is too strong is bad, but too weak is also a cancer for democracy. But the key to maintain the balance is by ensuring that the people are engaged.
Yeah, I think that's that it sounds very easy, but it's not very easy.
Yeah. Do you have any examples based on like your studies on when people are able to push either to if the constitution if the court becoming too weak, then they make it stronger to put it the balance, or if they are too strong, then the public can.
I think.
Is there any cases?
Well, I think you spoke about Israel a few minutes ago, and I think that's a case where there was a lot of public opposition to those changes, and I think there was some reversal to that. I think there have been incidents in the United States where there have been attempts to. So back in the 1930s, the U.S. Supreme Court at that time was very much opposed to legislation that was designed to deal with the Depression. And so they were striking down progressive economic legislation. And President Roosevelt threatened to increase the size of the court from 9 to 13 and to put 4 people on the court that agreed with him. And in that case, the court corrected itself. There was a judge who decided to change his vote in a very important case, and that reversed all of those decisions that were going against Roosevelt. So he didn't go through with what was called the court packing plan. So to some degree, courts can, when courts start to get too powerful, they can become self-correcting, and that's because as I said earlier, their political power depends on their legitimacy, and if they get too out of sync with the political views of the political system in which they're located, they have to worry about backlash. So they will self-correct. Courts
because they will lose legitimacy.
Courts can be self-correcting. How do you deal with a legislature that gets too powerful? Again, it's the people who have to live under the Constitution have to take some responsibility for protecting that Constitution.
I think that's the key today. I think if we can take your ideas to the Indonesian context, we see good news and bad news. The good news is I do agree with your observation that the fact that the candidates are accepting the results of the decision of the Constitutional Court shows the resiliency of the Indonesian democracy. Although they still have notes, I'm accepting and not doing some revolt or anything, but this is wrong. They maintain their position, and that shows actually.
But that's actually very strong. To be able to accept and act in accordance with a decision with which you disagree is actually sometimes a very difficult thing to do. It's a mature thing to do.
And it's showing the resiliency of Indonesian democracy. But at the same time, we also learn from your studies that a weakened constitutional court is a bad sign for democracy.
Well, if it gets to the point where, I think a court that would be completely feeble and completely unable to perform its essential function in a constitutional democracy would be a sign that somehow that constitutional democracy has, maybe when I said cancer was too strong a word, but that constitutional democracy has
It's a big challenge.
It's a big challenge. Yeah, it's become a little bit dysfunctional. That's for sure.
Yeah. And there are concerns about that currently in Indonesia, although it is of course debated.
Yeah.
But then I think the main point, the most important point that I learned from you today is that if that happens, it is very much up to the public, up to you, up to us to ensure that democracy alive, that constitutional democracy alive, and the balance are restored.
Yeah, so it's very important. Constitutional democracy does not belong to the executive, does not belong to the legislature, does not belong to the judiciary. Constitutional democracy belongs to the people who must live under the Constitution. And they have to take responsibility for ensuring that their constitutional democracy remains vital and develops properly. And that sometimes means accepting decisions with which you disagree, whatever side you're on. So it would have been an interesting thought experiment. What if the decision in the Constitutional Court's, what if the Constitutional Court's decision this week had been 5-3 in the other direction? What would the elected president?
There was already a demonstration outside.
What would he have done? Would he have said, "All right, I accept the decision. Let's go back and do that"? That would have been a real test. But it's a thought experiment, not that we won't know about. So,
but now we have the reality in front of us. But whatever your side is, I think your point about the important role of the public is very much in front of us today. So do you have any final comments on this issue?
Well, look, I think it's, I think for me as a political scientist, trying to understand the dynamic relationship between the judicial branches of government and the political branches of government, if I can use political in the narrow sense of the executive and the legislature for a moment. I think that it's very interesting to understand that dynamic and to think about the role that the people who live under a constitution play in making sure that that dynamic is a healthy and vigorous one and keeps the constitutional democracy alive.
Thank you very much, Professor Manfredi.
Thank you very much.
It's very enlightening.
It's been a pleasure. Thank you.
And we do hope to have more exchanges like this because McGill University and Faculty of Social and Political Sciences of the Universitas Indonesia is now in process of developing stronger cooperation, and hopefully that would not only strengthen the academic life in both universities, but also strengthen the democracy in both nations.
Look forward to having more fruitful collaborations with Universitas Indonesia across a wide range of disciplines.
Thank you very much,
Thank you,
Professor.
Thank you.